Hello everyone, in this video we are going to cover current legal general knowledge, especially for Delhi Judicial Services Examination 2023, and this is part 1 for this topic, current legal general knowledge, of which numerous questions are asked in this examination. So even in the main examination, this is a separate subject. So let's begin the video. So we will begin with the Collegium of Supreme Court. So Supreme Court Collegium consists of 5 judges, including the Chief Justice. So you must be knowing the Chief Justice of India is D.Y. Chandrachud, who is going to be the longest serving Chief Justice, as well as there are 4 other judges in Collegium, as consist of 5 judges. In Supreme Court, the Collegium consists of 5 judges, and in different high courts, a Collegium consists 3 judges. So Collegium of Supreme Court, the Chief Justice of India, D.Y. Chandrachud, Justice B.R. Gawai, Justice Surya Kant, Justice Sanjay Kishan Kaul, and Justice Sanjeev Khanna. So this is the Collegium. It can be asked, the question may be that who amongst these judges is not comprising or not there in the Collegium, and you have to remember these 5 names. You must be remembering Justice D.Y. Chandrachud, but in other 4 there may be confusion. So just remember these names. These are the 5 judges of Collegium. There are some authorities and their chairmen which belong to different legal fields. So the law minister, obviously, Arjun Ram Meghwal, the auditor and comptroller general of India, Shri Girish Chandra Murmu. So Girish Chandra Murmu is the auditor and comptroller general of India. The chief election commissioner, Rajiv Kumar, chairman of NGT, National Green Tribunal, Prakash Srivastav. The acting Chief Justice of Delhi High Court. May be asked that, as we know, you know that the Chief Justice of Delhi High Court has become now the Judge of Supreme Court, Mr. Justice S.C. Sharma, and his parent High Court is High Court of MP. Now the Chairman of National Human Rights Commission, Arun Kumar Mishra ji, Attorney General of India, R. Venkataramani, the Chairperson of the National Company Law Appellate Tribunal, Justice Ashok Bhushan, and the chairman of 22nd Law Commission of India. Now the current Law Commission of India is 22nd Law Commission, and its chairman is Justice Ritu Raj Avasthi. So these were some important authorities and their presidents, chairman. Now there are some new appointments, recent new appointments in Supreme Court. So right now, after the appointments of 3 new judges, the strength of Supreme Court has been to maximum, which is 34. The newly appointed judges are Satish Chandra Sharma from Delhi High Court, Justice A.G. Mashi, Chief Justice of Rajasthan High Court, Justice Sandeep Mehta, CJ of Guwahati High Court. So these are the 3 newly appointed judges of Supreme Court. You must remember the name. Now recently the Parliamentary Standing Committee on Home Affairs, इन्होंने recommend किया है that the offence of adultery be retained in the Bharatiya Nyaya Sanhita. As you know, the IPC is being replaced by the new Bharatiya Nyaya Sanhita, and इसको now the adultery would be part of the new Bharatiya Nyaya Sanhita, as it was earlier in Joseph Shine case. It has been held unconstitutional and was held to be no more a crime, but now it will be part of new Bharatiya Nyaya Sanhita, and it would be gender neutral, which means adultery earlier was not gender neutral. That is why it was held unconstitutional, but now it would be part of new IPC, and it would be in a gender neutral form. Recently, Honorable Supreme Court has held that there would be no right of hearing to accused before police. The right to be hearing and opportunity of hearing before police before filing of charge sheet, as it was held by High Court of MP, that there such opportunity would be given by the police to the accused. But later on, before the challenge, it was challenged before the Apex Court. The Apex Court in Shiv Kumar Sharma versus State of MP held that there can be no such opportunity of hearing be awarded to the accused before filing of the charge sheet. So Shiv Kumar Sharma versus State of MP, this is the citation. Recently, the 3 judges bench of Supreme Court of India, comprising the Chief Justice of India, Justice J.B. Padiwala, Justice Manoj Mishra, directed all the high courts that they must ensure that no member of the bar is denied to access to video conferencing while they are hearing the matters, the arguments through the hybrid mode would be available to all. So they have stated even the parties in person and the arguing counsels, the advocates, they will have this facility of hybrid hearing. So this was the case Sarvesh Mathur versus Registrar General High Court of Punjab in Haryana, जिसमें 3 जजेस बेंच ने कंप्राइजिंग चीफ जस्टिस ऑफ इंडिया बोला है दैट सारे हाई कोर्ट्स में देयर वुड बी हाइब्रिड हियरिंग मैथड फॉर आर्ग्यूइंग द केसेस. Recently, 106th amendment to the constitution came in and the new clauses were added for the reservation of seats of women in Legislative Assembly of Delhi, Lok Sabha and Rajya Sabha, and 1/3 women reservation in Legislative Assembly of every state. So, especially for Delhi, Article 239 capital AA is there, as 1/3 seats for women in Legislative Assembly of Delhi were made there, and these were the amendments that for total capacity of the membership there in the assemblies, there would be 1/3 reservation for women. So, but the reservation जो effect में आएगा, it would come after the delimitation of seats. So, जब delimitation of seats होगा, उसके बाद इस amendment को effect में लाने के लिए इसको बनाया गया है. So, it has not now come in force, but it will later come after delimitation of seats. So this is the amendment, 106th amendment. 239 AA is for the reservation in Legislative Assembly of Delhi. 330 is there for reservation of seats for women in Lok Sabha or House of People, Rajya Sabha, and 332 capital A is there for reservation of seats, 1/3 seats for women in the Legislative Assembly of every state. So this was the amendment. Recently, test identification period was challenged. It may be violative of Article 20 Clause 3, but the Supreme Court stated that it is not violative of Article 23 of Constitution, and accused is bound to take part in test identification period, which is also known as in abbreviation TIP. And this was the case Mukesh Singh versus State of NCT Delhi 2023. So test identification period was challenged in this case, and it was held to be constitutionally valid. Recently, in Harindra Rai versus State of Bihar 2023, it was held that FIR is a public document and can be dying declaration too. So, under section 74 of Indian Evidence Act, there is the category of documents which are held to be public documents, and that definition of public documents also includes FIR. And if a person who is giving the complaint, filing the FIR, dies later on after recording the FIR, that statement can be treated as a dying declaration. So it is a recent judgment. इसमें ये बोला that FIR is a public document, and that also can be used as a dying declaration if the person who is giving the information dies after the course of filing FIR. So this is the case Harindra Rai versus State of Bihar. Recently, Honorable Supreme Court held that divorce can be granted under Article 142 of Constitution of India. Constitution of India. 5 judges bench of Honorable Supreme Court held that divorce can be granted and discretionary power could be exercised under Article 142 of the Constitution for dissolving the marriage on the ground of its irretrievable breakdown to do complete justice, even when one of the spouses opposes the prayer for the dissolution of marriage. So it was held in Dr. Nirmal Singh Panesar versus Mrs. Paramjeet Kaur Panesar. This is the citation. And so, as you know, there was this judgment in which same-sex marriage, it is known as same-sex marriage case, in which Special Marriage Act was challenged, that it is violative of Article 14 as it does not include registration of marriages for the queer people, LGBTQ people. So it was challenged before the Honorable Supreme Court of India, and 5 judges bench of Supreme Court heard this matter and decided, saying that the act is not violative of Constitution, and held that same-sex marriage cannot be legalized and cannot be there under included there in Special Marriage Act. And it stated that the question of same-sex marriage is up to the country's parliament to decide. It is the duty of parliament to first decide that what should be the rules regarding same-sex people who are living in the people who are living with same-sex partner. So it is the duty of Parliament to decide it first. Then also stated that 3 out of the 5 judges disagreed with the Chief Justice and Justice Kishan Kaul that on adoption rights for LGBTQ people. As the Chief Justice and Justice Kaul stated that there can be right to adopt the children to the LGBTQ people, that they can adopt the child, and there may be some guidelines for that. But other 3 judges did not agree with the Chief Justice and the Justice Kishan Kaul, and stated that adoption rights cannot be given to queer people, and agreed on that Special Marriage Act cannot be interpreted in a manner that as to enable marriage between queer persons. Honorable Chief Justice stated in this case that an exercise to determine whether the Special Marriage Act is unconstitutional because of under-inclusivity would be futile because of the limitations of court's power to grant a remedy. So just because the SMA, the Special Marriage Act, was not including the queer people, the LGBTQ people, it doesn't mean that it must be held unconstitutional or violative of Article 14. Now, the 5 judges also stated that the centre will constitute a high-powered committee to examine concerns of same-sex people. So the judgment name is Supriya Chakravarti and others versus Union of India. This is the citation. Supreme Court recently also upheld the constitutionality of Insolvency and Bankruptcy Code. So it was the same was challenged. This act was challenged before the court, and it was held by the court that the challenge was that the personal guarantors in the act were not provided an opportunity to represent or challenge the initiation of insolvency resolution process or appointment of the resolution professional. So this was the challenge, and it was held that it is unconstitutional. It is unconstitutional process, and it is discriminatory. But the bench held that these provisions cannot be held unconstitutional for not affording an opportunity of hearing to the personal guarantors before the insolvency petition filed by the creditors. The changing the adjudicatory role under those provisions would amount to rewriting the legislative function. Again, it has said that the legislative functioning cannot be disturbed. Rewriting the provisions is not permissible, as judiciary cannot overreach through its functionality. Third, that the natural justice principles cannot be applied in a straitjacket manner. Their application could vary depending on the situation. So the IBC code was held constitutional. This was the judgment. Surendra B. Jivrajika and others versus Omkara Assets Reconstruction Private Limited. This was the citation. Recently, 7 judges bench has been formed to re-examine P.V. Narasimha Rao judgment of 1999. So सुप्रीम कोर्ट ने लेजिस्लेचर्स की इम्यूनिटी के रिगार्डिंग जो उनको क्रिमिनल प्रोसिक्यूशन फॉर ब्राइबरी चार्जेस स्पेशली फॉर देयर पार्लियामेंट्री एक्टिविटीज़, जो इम्यूनिटी उनको पीवी नरसिम्हा राव वर्सेस स्टेट इस जजमेंट में 5 जजेस बेंच ने अपहेल्ड करी थी, उसको अगेन रीलुक करने के लिए 7 जजेस बेंच को कॉन्स्टिट्यूट किया है. सो द रीज़न वॉज दैट टू कॉन्स्टिट्यूट दिस जजमेंट ऑफ झारखंड हाई कोर्ट, सीता Soren versus Union of India. Jharkhand High Court relied on the majority decision P.V. Narasimha and refused immunity to a member of Legislative Assembly as she received money for voting in favor of bribe giver and didn't vote accordingly, for which she was prosecuted. So after this was again challenged before the Supreme Court to relook this judgment P.V. Narasimha Rao versus State. It was a judgment of 1999 in which it was held by the 5 judges that immunity to MPs, Member of Parliament, as per Article 105 Clause 2, including the speech or vote made in furtherance of receiving illegal gratification / bribe for making a speech or voting particularly. So this immunity under Article 105 Clause 2 was held to be also include the speech or vote made in furtherance of receiving illegal gratification, bribe for making vote or speech. So this judgment is again to be relooked by 7 judges benches. Recently, one Madras High Court's judgment was challenged before the Honorable Supreme Court. In Madras High Court, S. Balakrishnan Pandian versus Inspector of Police. it was held that marriages performed by the advocates are not valid, before the advocates are not valid, and that Suyamma Yathai marriage, self-respect marriages cannot be solemnized in secrecy. So this is also known as self-respect marriage case. So it was held by the Madras High Court that these self-respect marriages performed before the advocates are not valid, and secrecy में इनको solemnize नहीं किया जा सकता. And this judgment was also relied in this Ivar San, Superintendent of Police, which is the judgment of 2023, and same judgment was challenged before the Honorable Supreme Court. So Supreme Court held, and overruling the Madras High Court judgment, held that self-respect marriages don't require public solemnization or declaration, and it was held that the advocates can witness the ceremony in personal capacity and not in professional. So it was held that the professionally advocates cannot do that, ceremonize these marriages, but in personal capacities they can witness the ceremony. And this decision of Madras High Court that self-respect marriages, they require public solemnization or declaration, it was held, it was overruled by the Honorable Supreme Court. So now the self-respect marriages can be done in privacy and need not public solemnization or declaration. Recently in Manoj Kumar Soni versus State of Andhra Pradesh, the Honorable Supreme Court held that disclosure statements cannot be the sole basis for conviction. The disclosure statement made under section 27, the memo of 27 as we call it, is not sufficient and cannot be the sole basis for conviction. Manoj Kumar Soni versus State of Andhra Pradesh. Recently, the Honorable Supreme Court has displayed new guidelines by Supreme Court for designation of advocates as senior advocates. So, as per the new policy, minimum age required is 45. Earlier, there were no such age restriction, but now minimum 45 age is required. Age may be although relaxed by the committee or the Chief Justice or any judge if he recommends a name. The new guidelines reduces down the publication marks. जो paper publication marks हुआ करते थे 15 से इनको 5 कर दिया है. So these are the new changes in designation of advocates as senior advocates guidelines. Recently, Delhi High Court has held in Bhakti Vedanta Book Trust India versus Bhakti Vedanta.in. It has held that in scriptures there can be no copyright, but in adaptations including providing explanations, summary, meaning, interpretation, or creating any audio-visual work like television series Ramayana, Mahabharata, or other dramas on scriptures. So scriptures पे कोई भी drama, interpretation, उनका creation, कोई adaptation, इनके लिए copyright protection can be there, but to the original scriptures there can be no copyright. So this is the judgment by the High Court of Delhi. Now there is this judgment passed by the Honorable Supreme Court regarding the exercise of power under section 156(3) of CRPC by the magistrate or judge. It was held that power under section 156(3) of CRPC is to be exercised on receiving a complaint or a police report or information from any person other than the police officer or upon his own knowledge before he takes cognizance under section 190. Then court explained that once magistrate takes cognizance, the magistrate has discretion to take recourse to this power under section 202 of CRPC. It cannot take this recourse under 156 subsection 3, but exercising power under section 202 of CRPC. And this judgment also overruled this judgment Devrapalli Lakshmi Narayan Reddy versus Narayan Reddy, in which it was held that power under section 156(3) CRPC can only be exercised at the pre-cognizance stage. So 156(3) is generally about directing the police to do investigation or file FIR. So it was the rule earlier that it cannot be done after taking cognizance, but the Supreme Court says that the same exercise can be done after taking cognizance under section 202 of CRPC. If it cannot be done under 156 subsection 3, but same can be done after even taking cognizance. So this is the judgment Kailash Vijayvargiya versus Raj Lakshmi Chaudhary and others. Recently, Kerala High Court advocate Bala Subramaniam Menon has secured a place in Guinness World of Record as he is the longest service lawyer at the age of 97. So, must remember this name, Bala Subramaniam Menon. P. Bala Subramaniam Menon. He is the Kerala based lawyer and he is the longest serving lawyer at the age of 97. Recently, Honorable Supreme Court has stated that certificate under Section 65 capital B of Evidence Act to prove electronic evidence can be produced at any stage of trial. So, this is a judgment by Supreme Court in state of Kerala, Karnataka versus T. Nasir Thadiya Tavida Nasir. So, this is the judgment that 65 capital B certificate can be produced at any stage of trial. The Supreme Court in Hari Prasad Kishan Sahu versus State of Chhattisgarh has explained 4 crucial circumstances to be proved in poisoning cases. So, 4 circumstances are has been explained by the Supreme Court that these are the circumstances which must be there in poisoning cases. So, first is that clear motive for the accused to give poison. Second, death due to poison. Death must be caused by the poison. Third, the accused should have the poison with him. And 4, opportunity to administer poison. So, these 4 circumstances must be proved in cases where the poison, the case is the death due to poison, and for that these 4 circumstances must be proved. So, this was the part 1 for general legal awareness topic there in Delhi Judicial Services. I'll assure all of you to come with second part of it. If you like this video, please subscribe the channel and share with your friends. Thank you so much for watching.